couple of technical issues. We are aware that the room's a little bit stuffy in it. We're going to try to get the temperature lowered. As you can see, we have extensions because this is such a large task force meeting. And so while most of the members up here have microphones in front of them, those sitting on the side tables are going to have to share the microphone. It's wireless, so it shouldn't be difficult to pass. And even though we can really hear each other fine within the confines of this room, when you look at the webcast, unless you're speaking directly into the microphone, it's really difficult to hear what you're saying on the webcast. So when you do speak, please grab that microphone and speak directly into the microphone. There should be also a little indicator light green to indicate that the microphone is on. And make sure that all your cell phones are off. Restrooms are down the hall to the right and to the left. So, since this is our very first meeting, and most of us know who everyone else is, but not everyone, instead of calling roll, I thought we could start on this side. And just please state your name and which group that you're representing, please.
I'm Janet Van Dyke, veterinarian, diplomat of the American College of Veterinary Sports Medicine and Rehabilitation, and founder of Canine Rehabilitation Institute.
I'm Karen Atlas, and I am representing the California Association of Animal Physical Therapists.
I'm James Sims, representing the California Physical Therapy Association.
I'm Spring Holland, representing Western University.
Valerie Fenstermaker, California Veterinary Medical Association. I'm the executive director.
Just want to remind you the rest to have it green. Thank you.
Okay. I'm Valerie Fenstermaker, executive director of the California Veterinary Medical Association.
I'm Nicole Billington, representing the Senate Committee on Business Professions and Economic Development.
John Klingborg, representing the Multidisciplinary Advisory Committee.
Val, I told you to make sure the green light was on. I'm Mark Nunez with Veterinary Medical Board.
Lee Heller, Veterinary Medical Board.
Jessica Walton, veterinarian representing veterinary acupuncturists.
Shalom Bar, I don't have to pronounce this out, I'm here representing consumers.
Erin Troy, I'm a veterinarian. I am representing the Certified Animal Rehabilitation Therapist.
Yen Cho, I'm a veterinarian, small animal surgery specialist. I'm representing UC Davis.
Carrie Schlachter, I'm a veterinarian diplomat of the American College of Veterinary Sports Medicine and Rehabilitation, and I'm representing the Northern Association of Equine Practitioners. Kristen Hagler, I'm a registered veterinary technician, certified canine rehabilitation practitioner, and I'm representing the proposed Academy of Physical Rehabilitation Veterinary Technicians.
And would any members of the audience care to identify themselves at this time?
With Forsyth with California Chiropractic Association. Jason Kaiser, Executive Officer of the Physical Therapy Board of California.
Tara Welch, Dr. Ryan, this fellow viewpoint practitioner.
Carol?
It's Tara Welch.
Tara.
Cindy Staley represents Sacramento Valley Veterinary Technician Association.
Dick Sullivan, Veterinary Medical Board.
Anne-Marie Donaya, Executive Officer for the Veterinary Medical Board. Shirley Jones, the State Board of Rehabilitation.
All right, welcome. The other thing I forgot to mention, if any members of the public want to come forward with any comments, you're also going to have to try to grab one of those wireless microphones, but be sure to put it back when you're done. And again, we can hear you, we really can, but everyone watching the web cannot hear you. So, unlike Donald Trump, I'm going to read from the teleprompter, or prepared opening statements that I made. Welcome to the first meeting of the Animal Rehabilitation Task Force, which has been established by the Veterinary Medical Board in response to a request by the legislature during the Sunset Review process. I want to thank all the task force members who have agreed to participate, and I would like to further acknowledge and commend you that you are here today upon your own dime, as regrettably we are not able to offer you any reimbursements. Don't forget, however, to add it to your resumes. As always, I admire the wisdom, the experience, and the knowledge you bring to the table, and I know that your participation stands testament to how important the issue of animal rehabilitation is to everyone in this room. It's so important that I would also like to acknowledge the efforts of board staff members Ethan Methez, Betsy Bynum, and Anne-Marie Del Manayo, who sent 3 requests to the Department of Consumer Affairs to have this meeting podcasted. Can anyone remember a task force meeting that has ever been podcasted before? Meeting room availability was tight, and we almost even had the meeting at the state capitol, which I would have to say I would have looked fabulous in one of those majestic hearing rooms they have over there. But thanks to the efforts of Deputy Director of Board Relations, Christine Lally, we're broadcasting to you today live from the hearing room of the headquarter buildings of the Department of Consumer Affairs. I do realize that other than the invitation to participate, you all as task members were not given much instructions on how the task force will be run and what the rules of engagement would be. And I'd also like to officially apologize, as some task force members did attempt to contact me to discuss the issues prior to the meeting. As chair of this task force, in the interest of fairness, I made the decisions to deny any of these requests to avoid any issues of bias or undue influence. You can even ask my fellow board members, Lee Heller and my co-chair, John Klingboyd, that even with them, I didn't engage in any pre-meeting discussions. It's yet to be seen if the decision not to prepare is going to result in a successful or a disastrous outcome, but it's my extreme desire to level the playing field and to have all interested stakeholders participate on an equal playing field. You'll all be receiving instructions today from our true fast legal counsel, who has just left my side, as to the rules of participation for this task force. But moving forward, I do expect that every task force member shares with all other members on the task force any information, discussions, or proposals that you may have. Establishing alliances and secret agendas is a waste of the tremendous talent that we have brought together. A winner-take-all approach, even if successful, always comes with unfortunate losses. I guess what I'm saying is, let's be nice to each other. My final words to you, in the opening statement that is, because you'll probably hear many more words from me throughout the day, would be in regards to the composition of the task force and a definition of your role here. When the legislature requested that this task force be created, the establishment of the composition and the appointment of task force members rested fully with the Veterinary Medical Board Chairman / President. Those terms are always interexchanged, which at the present time, I am told, is me. It is true that the board staff was accumulating a list of names of individuals that, on their own, had contacted the board to express their interest in participating on this task force. At no time did I, any past or present members of the Veterinary Medical Board, or any members of the Veterinary Medical Board staff actively add any names or withdrew any names from this initial list. While I was contemplating the composition of the task force, I was presented this list by Veterinary Medical Board Executive Officer Anne-Marie Del Minayo. And my initial response was, how am I going to make this a fair process? How am I going to create a task force that brings to the table every voice from all aspects of animal rehabilitation? In the end, I made the decision to first establish a list of stakeholders that I felt would provide representation from all aspects of animal rehabilitation. I showed this list to legal counsel, who has returned to be by my side, because you learn very quickly that in this world, everything should be shown to legal counsel first. Legal counsel, Kurt Hepler, made some minor recommendations to the list of stakeholders, and that was the list that was presented at the last meeting of the Veterinary Medical Board on April 21st, 2016. The next step was to send the invitations to the various stakeholder groups that had been identified so that they can decide amongst themselves who they felt, who they would like to serve as a representative on this task force. By doing it this way, I felt it would avoid any possible impression that I was stacking the deck as to the composition of the task force. We did not include any requirements to serve on the task force. In other words, you didn't have to be a DVM, or you didn't have to have certain certifications, or you didn't even have to be from this state. And we didn't have a review process on the acceptability of representatives that were sent to us. I had faith that each stakeholder group was going to send the right representative with the right qualifications to represent the group. I do hope that everyone serving on this task force, everyone sitting in this room, and the countless others, thousands, watching on the internet, acknowledges the efforts that went into trying to establish as fair and inclusive task force as possible. As you may have guessed, we received complaints, but in the end, I strongly believe that we accomplished our goal. I would also like to remind you that although you are here today to voice the opinions and positions of your various stakeholder groups, you have been invited by the California Veterinary Medical Board to participate in discussions that may result in changes to the California Veterinary Medical Practice Act. The Practice Act was developed and is enforced by the California Veterinary Medical Board with the foremost charge of consumer protection. So today, I would like for you to actually consider yourselves as members of the California Veterinary Medical Board. I don't mean that in any official capacity whatsoever, legal counsel. I don't have that authority. And I want you to remember that we're not here as advocates for the profession, for the professional or financial gain of veterinarians, of physical therapists, or of any other group. We are here for the consumers of the state of California and for the animal population of this great state. It's my hope that participating task force members who are not licensees of this board recognize our sincere desire to hear the opinions of all stakeholders to establish a position on the issue that is well thought out and well developed. The health and well-being of our patients depends on it. So, mostly, do I have to ask for a comment?
You might just want to ask, Mr. President, if there's any comment from the board as we take off, or any public comment as we commence here.
Usually in board meetings, whenever you present an agenda item, committee members or board members have the ability to ask questions or provide any input. And then members of the public also have that availability, so we will conduct this task force in a similar manner. Do you have any comments about my opening statement?
Mr. Chair, I just wanted to thank you for yet again leading us gracefully, graciously, and humorously towards work that will, we hope, come to a common understanding of what's in the best interests of the consumers of California. So thank you.
You're welcome. Any members of the public? Okay. Agenda item number 4 review of the objectives of the board task force, and that is going to be, do you have a PowerPoint presentation? Or no?
No one does at this point.
Okay.
That I'm aware of. You covered it in your opening remarks, so I think we can move on from that.
Okay. So, are there any members of the task force that have any questions on the objectives of this task force?
Chair Nunez, this might not be the right time, but at some point I think it would be helpful for all of us to clarify what we're not doing. That is, what are we focusing on versus what's not on the table? Because I know that's been a consumer challenge. Things like MSM, for example, that
Okay.
what is the most specific objective that this task force has been charged with?
Okay.
Might also help the public who is watching.
Yeah, if you can just kind of review the package that all task members have received.
Okay.
Just a little bit of history.
So the public document that was sent out to hopefully mirror some of the issues today that we're going to address. There we go. The public document that was sent out recently that will hopefully reflect what's on the agenda is a bit of background about how we got to this point. Specifically, the background about the Sunset Review recommendations that came out of the joint legislative committees of the Senate and the Assembly. And the board had been grappling with this kind of emerging trend of animal rehabilitation for many, many years. And one of the issues that surfaced was this kind of open-ended practice by unlicensed personnel dealing with animal rehab. And it was a very broad-based kind of approach to what is animal rehabilitation. There's complementary modalities such as massage and exercise. And so I think there was this very wide net cast at first that we looked at all of those different therapeutic modalities that may not be related to medicine, but in turn are supposed to be for the animal's overall well-being. And then as the Veterinary Medical Board began to kind of parse out what really is in the scope of practice of veterinary medicine, and that's medical treatment, that's diagnosis, treatment, and prescribing, we really had to narrow how we viewed this rehabilitative field. So in the background paper of the 2015-2016 Sunset Review document, we addressed some of the challenges that the Veterinary Medical Board has had in terms of regulating this kind of emerging trend that seems to have its own niche in the world of animal medicine and animal therapy. And we are struggling with the best approach to, is this a regulatory platform? Or is this something really that we're looking at maybe a statutory fix? And I don't know who that we is. Because currently the practice of veterinary medicine includes these things, and the definition is in your packet. And so is the background document. With the background, the legislative staff came up with a recommendation before the Veterinary Medical Board, which says they recommend the Veterinary Medical Board comprise a task force, and this task force needs to include all stakeholders: veterinarians, RVTs, animal rehabilitation and related animal industry professionals, and consumers. And the idea of this, including the members of the legislature, the idea of this is to further examine the issue with a broad spectrum of personnel who are addressing these areas from a different perspective. The Veterinary Medical Board is charged with making a recommendation to the legislature. So the Veterinary Medical Board, as of January 2017, will be discussing whatever recommendation comes out of this task force. We presume that as of today we will have one more meeting of the Animal Rehabilitation Task Force before we are able to hopefully develop a recommendation. But what we are not attempting to do today, sorry about that, is we're not attempting to change statutory language. We're not attempting to look at areas that are already regulated, that being chiropractic medicine, as included in the regulations for chiropractic modalities. And we are not attempting to regulate things that are outside veterinary medicine. And we'll get into the details of what that means as we move on in this discussion. I don't want to read through all of this because I know you are all perfectly capable of reading the background document and understanding some of the finer points. I will entertain any questions as we move forward about scope of practice, mission and vision of the board, and what our intents are here today. Thank you.
Are there any questions from members of the task force in regards to the objectives of this task? And Anne-Marie has said we do anticipate for there to be a second meeting before our deadline of January 2017. And later on, Kurt will probably give us rules of what we're able to do in between meetings and what we're not able to do in between meetings and so forth. Are there any? We have another task force member that's joined us.
Hello.
And I'm not. You're not in trouble. But I'd like to just give you the opportunity to introduce yourself and let us know which group you're representing.
Hi, I'm Carrie Ann Calais, and now I know that Arena Boulevard is North Market Boulevard. I'm representing the consumer section.
Where did you come from?
Good morning, Alyssa Silva with the Assembly Business and Professions Committee.
Would you like me to give my opening statements again? Are there any additional questions from members of the task force in regards to the objectives? Is there any questions or comments from members of the public in regards to the objectives of the task force?
Mr. President, if I may, and members, Ms. Tamaniana, it's my understanding that this August body is going to make a recommendation to the full board on how to proceed, and then the full board is going to make its recommendation to the Sunset Review Committee at the appropriate time. Is that correct?
That is correct.
And I believe it's pronounced August. Agenda item number 5, review of the mission and the vision of the Veterinary Medical Board, consumer protection. It has down here that Anne-Marie was going to present that. I assumed it was going to present. He's always reminding us of that, but Anne-Marie.
Yeah, sure. It's in the background document on page 3. And I think it bears, at least for the sake of those who are not in board land all the time and understand that we have 2 very pertinent missions. And the first mission, as it reads, is the actual statement that the board develops on its own. And that statement is to protect consumers and animals by regulating licensees, promoting professional standards, and diligent enforcement of the California Veterinary Medicine Practice Act. With that is something that legal counsel will address as our statutory mandate of priority of the board is protection of the public. There's actually a business and profession code section that lays out under the strictest terms that protection of the public shall be the highest priority of the Veterinary Medical Board in exercising its licensing, regulatory, and disciplinary functions. Whenever protection of the public is inconsistent with other interests sought to be promoted, protection of the public shall be paramount. So obviously that's a very powerful statement in terms of our purpose, our goals and objectives, and it's the underlying course in our strategic plan. And finally, the vision of this board, which is very lofty, an environment in which Californians have access to high-quality veterinary care for all animals. And that completes the mission vision.
Would legal counsel like to add anything to that?
Except that I don't know what I'm going to talk about now. Anne-Marie stole it.
So task force members, I promise you, we will be getting to the nitty-gritty of the issues. But it's important that everyone understands how the Veterinary Medical Board works. Being a state regulatory body, there's certain things that we have authority over and certain ways that things must be done. And I thought that would be helpful if all the task force members knows what constraints and what liberties we have in anything that comes out of this task force. So it may sound like we're not talking about the issues, but I think it's important to everyone on the task force to understand what we can and can't do as the veterinary medical board. So try to listen to these presentations, keeping that in mind. And having said that, does anyone on the task force have any questions about the mission and the vision of the Veterinary Medical Board? Hearing none, is there any questions or comments from members of the board? Okay. Agenda item number 6. Review of applicable statutes and regulations. And this is the PowerPoint presentation working?
Yes, it is, 2 seconds.
Yeah. When we get to statutes and regulations, this is where it's a challenge to really stay awake. So make sure you have something to drink.
We're not.
Because
Please bear with us, members, we're trying to, I did prepare a PowerPoint presentation, but apparently the sneakernet methodology of walking it from HQ1 to HQ2 here, something happened to it, so please excuse our technical difficulties. I think we'll have to brighten that up a little bit. Okay. Can everybody hear me? Let's just, okay. Good morning, everybody. My name is Kurt Hepler. I'm a supervising counsel with the Department of Consumer Affairs. And before I begin, I used to be counsel to the Physical Therapy Board and also to the Medical Board of California. And right now I'm counsel to this, to the Veterinary Medical Board, as well as the Optometric Medical Board, or California State Board of Optometry. So this is just an introductory slide. Welcome aboard. Mr. Chairman, if I may, we certainly have a quorum here. And also, so let's proceed. So if I could have the next slide. I apologize, we're kind of doing this the old-fashioned way. So some basic information. Within the Department of Consumer Affairs, there's about 40 boards, bureaus, programs, that sort of thing. And these are, at our core, will all essentially licensing agencies. And what I mean by that is we grant you the authority to do something that if you don't have the license, you can't do it. For example, there's a very good reason why I don't practice open heart surgery. Well, actually 2 good reasons. A, I don't know how, and B, I don't have a physician's or surgeon's certificate. So if you think about it, when you're a licensing agency, essentially you do 3 things. You issue qualified licenses to applicants that are qualified. Okay, you provide regulatory oversight, and you discipline, you investigate complaints, and you take the appropriate enforcement actions. If you think about it, it's kind of a rule of 3. The board decides who's going to get into the profession. They're going to decide what they do, what they do when they get in there. Like you have to notify if you change your address, if you have a premises permit. We provide regulatory oversight. And then you think about the 3rd bullet there, is you're going to help somebody determine how they're going to leave the profession. Some of you, when you leave the profession, will get a retired license. You'll still get great parking at the veterinary hospital or whatever. Some of you, we're going to help you leave the profession because we'll discipline your license. We'll suspend it or revoke it. So who gets into the pool, what they do when they get in the pool, and how do you get out, okay? So next scrolling slide, please. Okay. So we talked a lot about statutes, and I'm going to talk about statutes. Statutes are enacted by the legislature. The legislature is the chief policy-making organ of the state. Just like in a board situation, the board members are the chief policymaker of the board. The legislature works for the entire state of California on every subject under the sun. And they enact statutes or the mechanism by which VMB is granted the authority to act. For example, we have specific statutory authority to issue a license, to suspend that license, and to promulgate regulations. And with that, those are the express powers. There also comes a little implied powers. For example, there's no statute in front of the veterinary medical board that says, and thou shalt open the mail, right? Because it's sort of implied that you really can't accept an application, or you really can't discipline anything unless you go to work and you open the mail or you answer the phone. So again, there's some implied powers as well, but not very much, right? Just those powers necessary to effectuate the express powers. So a little bit of implied powers, a whole bunch of express powers. So next slide, next scrolling slide, please. Okay, let's talk about regulations for just a moment. So regulations are kind of the mini law. They're made by the agency in accordance to the rulemaking process. They are clearly subordinate to statute. So statute prevails. And the purpose of a regulation is to implement, interpret, or make specific statute. For example, most of the practices acts in consumer affairs has something like, and if you want a license for X, thou shalt submit an application provided by the Border Bureau. Okay, so where do we find those little nuts and bolts details? We find that in regulation, stuff like forms, like an application form, or some other form that details the procedures. For example, most of the regulations have something as mundane as the principal office of the Board of X is located at this address. Okay, because we want to fill in the gap in statute. So very, very, very important, but they are subordinate to statute. Okay, statute prevails. Sir. Okay, now what can't a regulation do? And this is kind of important because I think there is some talk about some regulatory constructs. So a regulation cannot enlarge, restrict, or impair a statute. Okay, cannot do those things. The regulation, the definition for a regulation to be valid must be consistent and not in conflict with the statute. So again, consistent, not in conflict, and reasonably necessary to carry out the statute's purpose. Cannot go beyond the authority of the agency. For example, no matter if we had wonderful rulemaking authority, neither the Physical Therapy Board nor the Board of Veterinary Medicine could say all framing construction contractors must be left-handed, because we can't do that normally, and we certainly couldn't do it by regulation. So regulation cannot go beyond the authority of the agency. Okay, now if we look at VMB, VMB issues one license for veterinarians to qualified applicants. It's a plenary license, just like the physicians and surgeons certificate issued by the medical board. Once you get that license or certificate, you're authorized to practice veterinary medicine. We do not license by specialty. And the scope of practice for VMB is determined right here. And you can see if you scroll down just a little bit, I think the most focuses on B, diagnosis or prescribes a drug, medicine, appliance application, and the rest of that eye test for disease of animals. So I think that's what we're focusing on. And from a practical perspective, an agency like any licensing agency or any administrative agency does not really get to enlarge its scope of practice by regulation. Otherwise, we'd have the quintessential scope creep or turf battles all the time. There's essentially two ways the scope of practice expands. Number one is the legislature intervenes and puts new words in the statute and says it's this or it's that. Or the second way sometimes it happens is the agency will cite somebody for unlicensed practice. That decision will go to a hearing, and then we may adopt that decision by precedent, meaning that whatever that stands for, that is now the practice of whatever the act is. Okay, so keep scrolling down. And again, this is more of the section that talks about what the scope of practice of veterinary medicine. And I know it looks like an eye chart, but it's not. And on number E there, the last word, equidae, I think that means horses, doesn't it? No, well, see. So. And see, if you look at number F, this is both a title and a practice act, because you can't, the reason that I, like I said, don't do open heart surgery is I can't practice that without a medical license, and nor can I call myself a doctor because I don't have that certificate. So this is both Title and Protection Act. That's an important concept. Next slide, please. Okay, you've heard this ad nauseum. The main job of the Veterinary Medical Board is to protect the public. And I actually took Anne Marie kind of stole my thunder there, but that's actually a statutory obligation. And that is, whenever we do our licensing, regulatory, or disciplinary functions, consumer protection is the paramount priority. Okay? Very important, because sometimes you'll hear something like the medical board or the veterinary medical board or some board within DCA is out to get a licensee, out to get a registrant, trying to get even, wants to wreak vengeance. Case law suggests that the purpose of these kind of disciplinary procedures is just to protect the public. It's not punitive, okay? It's very important to remember. I know I'm straying off topic because I kind of want to give you a background of what any licensing agency within consumer affairs is up against, kind of our obligations. Sir, if you wouldn't mind. The Physical Therapy Board of California, they're part of DCA too. They issues licenses and enforcing the Physical Therapy Practice Act. Guess what? They have the same obligation, protection of the public. Okay, so whenever they do their thing, their licensing, regulatory, disciplinary functions, public protection is their optimum goal as well. So you can see both boards are aligned in that common goal. A little bit more. A little bit more scroll, sir. Okay, sorry. And they have rulemaking authority as well. They can promulgate regulations like I talked about. Here's the scope of practice for a physical therapist, and I've highlighted a couple things because I think they are important. So physical therapy means, again, more eye chart action, but you can see I said mental condition or bodily condition of any person, and if you go down to about the 8th line, it's the wellness of individuals. So again, we're talking about people here. So I would suggest that no matter whatever bubbles out of this task force, I think one of the considerations you're going to have to give is whether that practice act can remain like it is, that scope of practice for a physical therapist can remain as it is to allow the provision of services to other than human beings. Because I think that's going to be a little bit of a challenge. Okay, next slide please. Any questions so far? Scopes of practice, regulations, the power of an administrative agency. I'll stop and questions, and I know CPR too, in case anybody nods over from boredom.
Okay, so task force members, I warned you. And I have a quick quiz for task members to see if you've been paying attention. For those of you who are familiar with the history of animal rehabilitation, has the board attempted to address regulations through statutes or through regulations up until this point? Who has the answer to that question?
Regulations.
Through regulations. That's correct. You were paying attention.
Okay, if no more questions, we'll go on to round 2, the lightning round, double jeopardy if you will. And so let's talk about the Open Meeting Act for just a second. So I've crossed the 50-year-old barrier, and every night when I wind down for the evening, I have to put my car keys in the same spot. And why is that? So I don't have to go looking for them tomorrow morning, right? Because as 50 teams start to forgetting a lot of stuff. So when you use a mnemonic device to remember some of the provisions of the Open Meeting Act, if I say Roy G. Biv, does that invoke anything for you?
Rainbow.
Color the rainbow, right. Red, orange, yellow, green, blue, what's the I stand for? Indigo, very good, and violet. And if I say Holmes, what does that mean to you? That's the Great Lakes, right? Huron, Ontario, Michigan, Erie, and Superior. Okay, so that's a lot of cerebral acumen that just went bye-bye. So instead we'll use something that a little bit easier to understand. That's popcorn. So popcorn is going to be our mnemonic. And this is how I got through law school, with a lot of mnemonics. So anyway, next slide, please. So the P is for public. The public has a right to attend these kind of meetings. They can record it. I think there was a question that bubbled up prior to the meeting. They can record this without being disruptive. That means they can both video record it and audio record it. They have the right to comment on the actions, exactly. That's why the chair always calls for public comment. Okay, that's your right, and you have the right to copy and inspect records that are given to the board. Okay? O is for open session. Since we don't do anything since this task force does not have the power to do anything under the APA, we don't grant examinations, we don't judge the executive officer. I know that's probably a secret wish, but we don't do that sort of thing. We don't do things under the APA. We don't deliberate on discipline or licensing. We're going to do everything is going to be warts and all in open session. Okay, we cannot go into closed session because something's controversial or embarrassing. It's going to be a warts and all. We're going to be out there talking about this open session and even the webcast. Next slide, please. So what happens if we don't do what we say we're going to do? We don't file the Open Meetings Act. Well, the decision or action could be invalidated, and theoretically there's a criminal charge of a misdemeanor. I don't really think those are going to be in play here, but this is sort of residue from an older slide, and I thought it's important to say the OMA has teeth, okay? Because the number one bullet is somebody could challenge the action or decision this place makes if we don't follow the OMA. Next slide, please. C is for communications, and if one thing the Open Meeting Act stands for is that decisions of the task force, decisions of a committee, decisions of a board happen at the agency meeting. Okay, they don't happen before, in a clandestine group, they happen there. And that's because you can't use a serial or hub and spoke communication methodology to discuss, deliberate, or take action on task force business. When we were probably 8 or 9 years old, we played that game called telephone. We all got in a circle. The first participant would say something and it would go around our little daisy chain or whatever, and by the time you got back, the final story that you got was way different from what you led off with. And we can't do that here, right? Okay, the OMA does permit contacts and communications between a member state body and one other person. So as I believe that this body is bound by the Open Meetings Act. Okay, and so what that means, it's sort of inconsistent with your work life or your personal life, where you prepare for a meeting, you kind of gather your lieutenants, you say, okay, we're going to rehearse. Here's what we're going to say, and I say to that, the OMA, the Open Meetings Act, is kind of cumbersome. It's kind of frustrating sometimes, but it's the law, and what it really stands for is that decisions are made at the meetings. Again, decisions are made at the meetings, so that you can prepare. If you want to talk to the executive officer, you can certainly do that. If you want to talk to me, like we say at the Hepler House, I don't count. I don't count as one of the people that you can talk to because I'm not a member of the state body. I'm the legal counsel. Ms. Del Minyayo is not a member of the board either, or the body either. She's the executive officer. Okay? So next slide, please. So O is for 1 + 2 is a meeting of a state body. Okay, so it includes any congregation, blah, 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 exception of an advisory committee with less than 3 persons without any delegated authority. For those of you who excelled in math, we have more than 3 people here. Okay, so we're going to be bound by the OMA. And that's kind of a big deal. That means every time we get together, we have to have a meeting notice. Talk about that in just a second. And we have to play by the rules according to the board's administrative manual. The rules of engagement, as the chair had mentioned, are Robert's rules of order. And that's what we're going to follow. We're going to take votes, not by raising our hands. We're going to roll call when we get to a voting matter. So those are the kind of rules. And of course, we're going to be webcast. So those are kind of the rules of engagement. Next slide, please. R is for roadmap, also known as the agenda. And the agenda's got to have a brief but specific description of what we're going to be talking about, the business to be transacted. And the test is, would somebody be able to read that agenda and reasonably conclude what we're going to talk about? And we can't use old or no business, and it's both a sword and a shield. And by that I mean, sometimes it'll shield you from talking about something that wasn't on the agenda, and the other time it's a sword because you really want to talk about something. Somebody had a really good idea about something that's not on the agenda, and we can't talk about it because the general rule of thumb is if it's not on the agenda, we're not talking about it. Okay? So when we get down to the section of our agenda about next steps or future items on the agenda, please use that opportunity to think, hey, I'd like to reserve room to talk about this at the subsequent meeting.
okay? At the next meeting, I wanna talk about this or that or whatever, so that we don't get down to the next meeting and we're kind of all looking at each other going, wow, wish somebody would have put that on the agenda, okay? So again, I would rather have you recommend that something go on the agenda, that way we can preserve the room to talk about it. And if we don't get to that, we don't get to that, but that's a far easier thing to do than saying, gee, I'd really like to talk about this, but it's not on the agenda, okay? So again, we'll talk about that a little bit more when we get to the next steps or the future agenda items on this agenda. Okay, so next slide, please. And winding down enters for notice, posted at least 10 days in advance of the meeting, setting forth the time and location and a contact person in the event more information is needed. And if teleconference meeting, locations must be specified, and these locations must be accessible to the public and ADA compliant. I don't know if this August body will go into teleconference, but teleconference as well. We're just 90 miles from Silicon Valley, a whole lot of networking horsepower over there. But please be advised that when you say open to the public, if you say your house, that can mean you making a lot of friends. I've had agencies suggest they'd like to meet in a bar, or they like to meet behind a closed gated community. I'll tell you right now, those things don't really work that well, because it's got to be open and accessible to the public. Okay. And now I'll just say, any more questions on that sort of thing? And again, my name is Kurt Hepler. In traditional board land, I think as Emery mentioned, I am the counsel to the board. I do not participate when we discipline somebody. I do not represent the complainant. I'm not a deputy attorney general. My job is more of a transactional representation. I do subpoenas. I do the Open Meeting Act thing. I do contracts. I do sit with the board in closed session as they make decisions about licensing and discipline, but I'm not an advocate. Okay. And when we get to that a little bit, I don't know anything more about cases than anybody else. So I just say that in case there was some question about what my role is. So again, thank you, Mr. Chairman and members, and I will rapidly go back to my seat.
So I'd like to just clarify a couple of points that you made, just in case there is some confusion from the task force members. Going back to when Kirk was talking about going into closed session, I just want to make sure that that doesn't mean that the board, me and myself and John, are going to go into closed session and leave you guys out. But that means that we, as a task force, can turn off the podcast and kick out all the audience members. We can go into closed session. So that's something that we have. I don't foresee any reason why we would choose to do so, but I just wanted to clarify that doesn't mean that we're going to go into closed session, in case anyone was thinking about that. I also really hope you understand the reason why it's requested and actually required that all discussions be made at the open meeting. We really owe it to the consumers to know what our thought process is and how we've come up to any decisions that we've made. And as chair, I'm like mom with eyes in the back of my head. I know that there's been emails that have been exchanged. So moving forward, we're all going to be open and forthright. And also just on the issue of agenda items, any member of the board has the option to request an agenda item be placed on the next agenda. But if it's not on today's agenda, we just can't talk about it because perhaps some people weren't prepared to talk about that issue, and it would be a little bit unfair to, quote, catch them off guard. That's why that rule is there.
Thank you for putting that so eloquently, Mr. Chairman. I would say as part of the importance of the agenda and items on the agenda are simply that you want to give notice so that some interested party would say, well, I don't really need to attend or watch because they won't be talking about this, and then all of a sudden as we start talking about that thing that they were interested in, they were essentially deprived of the right to participate and deprived of the right to know what's going on. So that's why That's why the agenda items are so important. So again, thank you.
Yeah, and I think there's been some instances where issues were actually voted upon that weren't on the agenda, and then they would have to be null and void if the board voted on issues that wasn't on the agenda, which would be a huge waste of time. Thank you for that presentation. It wasn't as torturous as I thought it was going to be.
That seems to be a lukewarm compliment.
Any members of the task force have any questions or comments in regards to agenda item number 6, review of applicable statutes and regulations? Sub 6A, Open Meeting Act. Any members of the public, questions or comments?
Mr. Chair, can I ask a really, really procedural question? Because it can help people in their planning. Do you have a plan for when we will take breaks or have a lunch break or anything like that?
I do not. But if anyone, is anyone feeling like a break right now? Let's take a bathroom break. 15 minutes. I promised you that we will get into the nitty-gritty, and I predict that the nitty-gritty will start to open up on the next item here. So again, as item number 7, the scope of practice of veterinarians, registered veterinary technicians, unlicensed assistants, and physical therapists. In the course of this discussion, I predict that some of you would like to add to this discussion, and also if you've brought in some supporting documents, now would be the time to present those documents. And also, we want to get something accomplished at this meeting, so it's not all about just listening to people present their cases. If during the course of discussion, some sort of motion starts to percolate in your minds, that's the time to potentially bring a motion up. But just let's move forward.
I have a point of information. Can you, I'm sorry I wasn't here earlier, but how many meetings do you envision this task force to come together?
We have to make a recommendation to the board at the January 2017 meeting. So I anticipate that there'll probably be time for just one additional meeting. There potentially can be some, did you cover that on what we can and can't do in between meetings as far as exchange of information or anything like that?
Right, Mr. President, members, so if the board would like to give ideas or comments to the executive officer or to me, you can certainly do that in the interim. But what there can be is there can't be circulating of emails or other information to try and get a collective action or collective straw poll or take the temperature of the board of the task force. So if you have something that you wish to, for example, a member comes up with a brilliant idea, he or she could send that to the executive officer, who can then send that out to all the members. But what can't happen is you can't start saying, hey, what do you think of this? Hey, what do you think of this? Hey, what do you think of this? That's what's not permitted, because then the board is now discussing, deliberating on something outside of a duly noticed meeting. Everybody understand what I'm saying? So if in fact you want to send me something, or the executive officer or the executive officers could come up with some research and say, I just found out that the state of Columbia is doing X on this issue. She could send it out to all of you. That's totally permissible. What can happen is that this side of the room then contacts that side of the room, that talks to this side of the room, and then we all agree that we're going to do something at the next meeting, because that violates the concept that these sort of decisions and discussions happen at duly noticed meetings. Okay? Sir?
There's also going to be a meeting of the Veterinary Medical Board next month. Is a report on the task force going to be on the agenda?
We can provide an update. It could be under your president's report before the board, because at that point it would still be a working committee. So you could provide an update to what was discussed and what will be discussed at the next meeting. And that would be helpful because there would be some advance notice for public participants that may want to attend the next task force meeting.
And I know that in the past, when presentations are made from committees such as the NVC, there is some feedback from the board as far as which direction they would hopefully like to see or answers they'd like answered. But I don't know if it would be appropriate in this situation because it was something that was requested by legislature, so it would be only a
report.
And
Yeah.
with no possibility of feedback from the board.
At such time that the committee makes the recommendation before the Veterinary Medical Board in January, the board at that point would have an opportunity to forward the recommendation of the committee, but also formulate its own response to that recommendation. But that would be after the work of the task force is complete, and there would be a recommendation out of this group before the Veterinary Medical Board. So I think in all fairness, we would have the actual task force recommendation and then perhaps the Veterinary Medical Board's response to that task force recommendation. Just one point of order, we do have another member that's joined us at the dais, and so we should recognize that. Sandy, would you like to introduce yourself?
Sandy Gregory, representing California RVT Association.
Thank you.
So I'd like to talk about scope of practice. I'd also like a ground rule that you set a time limit so that you can hold a hook and gag me when I'm done, and we can set ground rules there. How long do I get to go for?
Generally, we don't really set time limits, but I think if you want to go with a sort of, I have a phone. If you want to give me a number, 4 or 5 minutes or whatever, I can certainly start the clock, and when we get down to the end of the time, I can gesture frantically.
Great.
Or something like that.
3 to 5 minutes should be enough. I'll be relatively concise. The veterinary profession is a unique profession in that when we look at the other health professions that are in Division 2 of the Business and Professions Code, for example, dentistry, medicine, nursing, chiropractic, acupuncture, podiatry, the veterinary profession encompasses all of those. All of those separate entities on the human side all fall under our one large umbrella. And it puts then me as a licensee in a position where I have to be very responsive and very honest with myself and with my patients and consumers about what are my boundaries. And if I overstep my boundaries, then I have a significant liability. Veterinarians also tend to interface one-on-one with their clientele. So we don't have a huge staff that comes in between us and our clients. So it's easy to tell when we have overstepped our boundaries and created issues. And where there have been problems with other health professions practicing beyond their scope, I'm proud to say that the veterinary profession in general, I think, has done a very, very good job. We think about scope, and one of the conversations that has come up at times has centered on expertise. Well, at this point in my career, 25 years in, I have spayed thousands of animals. I have delivered hundreds of babies of various species. And so one could say that I am an expert in reproduction. But no one is suggesting that I go open a shop and perform hysterectomies on women, because I have certainly done far more hysterectomies than I think the average OBGYN has done. So that notion is absurd. And so we have to be clear about scope, and that we have these very specific boundaries, and those boundaries and those limits prevent me from going out and working on mounting gorillas and dolphins, which I am legally entitled to do, but they're beyond what I know is my scope of practice. Personally, I understand that. I have seen this profession grow over the 25 years. When I went through school, I got 6 hours of dentistry laboratory. That was what I got. And yet now we're providing endodontics and all kinds of procedures. So What do? When we add the number of hours we are in school, and when we add the number of hours we have for CE over the course of our career, roughly half of what we learn as a veterinarian we learn in the educational curriculum, and the other half we learn out in practice. And we have many resources available to us to do that. We have certainly continuing education meetings, we've got these days webinars, journals, newsletters. I mean, I don't have to run through the litany for you, but they're all there. And the ability for us to get hands-on training, video training, etc., exists for these modalities. When we start entering a scope of practice, and again, dentistry would be a good one, ultrasonography would be another, we have historically formed partnerships with the human medical side, and they have come in and they have trained us. And they have taught us how to do things, not happening in my practice, but things like a heart valve replacement, kidney transplants, or again, even things as simple as ultrasonography or dentistry. And then after we have reached a certain level of expertise, those professionals have gone back, they consulted with us, and then they never assumed case responsibility, that was ours. And then they have gone back into their scope of practice. And we see then, as we gain more and more expertise within our profession, that we start to form our diplomates and our various colleges and whatnot, which we have one in sports medicine and rehabilitation now. So scope of practice is very interesting in veterinary medicine because it means everything that has to do with animal. But it is then the responsibility of the individual to know what is appropriate and what isn't. And just one last thing and then I'll stop. And that is one of our biggest issues to this point has been defining what animal rehab means. And I think we erred significantly when we included wellness modalities such as massage, stretching, and exercise. Now our error was, quite frankly, we looked at the Physical Therapy Practice Act, which includes that. But we realized on the animal side, we want to exclude wellness modalities. We want people to be able to seek those services wherever they want for their animal. It is when we're talking about an injury, that's when we're talking about animal rehab. How'd I do? I did. Okay.
I think it would be helpful if I can ask legal counsel to make some comments about what is defined as practice of veterinary medicine, what the scope of practice is, and I would also request that a member of the physical therapy community make some comments on the scope of practice of physical therapy.
Certainly, Mr. President, members, I think the scope of practice, not the standard of care, because there's a huge difference, but the scope of practice is sort of outlined in the statute that I talked about. And rather than just going through the eye chart that we talked about, I think it's really important that we all kind of look and parse this statute out a little bit about to what it really means, because the legislature in this has spoken. Again, we go back to what the legislature is the chief policy-making organ of the state. And it says a person practices veterinary medicine, surgery, or dentistry. And remember, we issue one license. The board issues one license. As Dr. Klingborg pointed out, theoretically, you could go from, I don't know, the ends of the spectrum in the animal world. But like I said, so basically the practice of veterinary medicine is you hold yourself out as a veterinarian. I think, like I said, subdivision B, you diagnose or prescribe a drug, medicine, application, or treatment of whatever nature, that's very broad language, whatever nature, for the prevention, cure, relief of a wound, fracture, bodily injury, or disease of animals. Pretty wide language there. C, administers a drug, medicine, appliance for whatever, again, carrying on the theme. D, performs a surgical or dental operation upon an animal. Performs an manual procedure for the diagnosis of pregnancy, sterility, or infertility of livestock or equidae. Or number 5, subdivision F, you hold yourself out as one. You use DVM or some other title or initial suggestion your doctor of veterinary medicine. So that's just sort of the scope of the practice of veterinary. I think when we get down to what an RVT can do, again, that's something that I think statute provides regulatory structure for, not necessarily a statutory structure for. So with that, I will shut up. Perhaps you want to hear from a physical therapist about what their scope of practice is.
Yeah, and again, I want to encourage task force members, remember that we like to have a definition of what the practice of veterinary medicine is and physical therapy because of consumer protection. These tasks that we are performing, at some point, we felt that they require a certain level of education and training and experience. It's something that's not expected of a layperson to do. The only time that I agreed with Judge Scalia, may he rest in peace, was when he said that he wants brain surgeons to do brain surgery. And so this is why trying to define what the scope of practice is, ultimately to protect the consumer. So who would like to make some presentations on the scope of practice for physical therapy?
I think that's my role here today. I'm Dr. James Sims, physical therapist. We have black letter law that's written out there, and you saw it in our previous presentation today of what physical therapists do. It needs to be recognized by this group and this committee that the physical therapist practitioner who's been involved in this process is a physical therapist that continues to have additional training, just like as you mentioned, in terms of you estimate half of your skill set that you currently use in contemporary practice is that what you acquired subsequent to your entry-level education as you go through that. So I don't need to reread the Practice Act to you, but I do look at the mission statement of the medical board being to protect the consumer and allow the consumer to have the best health care for their animal. And if the broadness of the statute of veterinary practice is so broad that maybe it needs to be tightened up, and obviously that's not a regulatory event because of the statutory trumping regulation, to clarify, that what is the best for the best interest for the consumer and the animal, and so that can happen. That can help clarify this. I think this has been kind of a can kicked down the road for many years that I've been involved in, and just only by a little bit predates my involvement for over 15, 12 years. That might be the reason why it's been so difficult to kind of get our hands around this and go. So the practice of physical therapy in terms of rehabilitative medicine, rehabilitative care for vertebrates, regardless of what kingdom they are from. I'll lay out there that for physical therapists, our training is 3 years of exclusive specialty area of training of rehabilitation. And the healthcare practitioner in the state and physicians will pretty much honestly say this, that therapists are the experts in the state, the licensed expert in the state to perform that task. And many times, a lot of stuff that we practice first is on vertebrates that aren't human, and be able to establish the safety and efficacy of those things. And so that's where our involvement with this and our Ethics and Practice Act well serves this board and this task force to help us get to an end for this issue.
Chair Nunez, may I make a request? I think it's really important that we're getting explained to us what the legal parameters are of the practice acts of veterinary medicine and physical therapy. I know for myself, and I don't know if this is true of others around this table, it would be very helpful to know literally what does a veterinarian study for 3 years? What is the curriculum? We've got people in the room who are from both of the states' veterinary schools, as well as what does a physical therapist study? What does an RVT study?
Okay.
And that will help us to know what people know.
I agree. It's actually going to be discussed in agenda item number 8. So we'll.
Apologies if I jumped the gun.
It's okay. I'm not mad. So when you really think about this, you can start to understand how this gets complicated, and this is why a task force was created, because when we talk about what is animal rehabilitation, there are lots of treatment modalities that suddenly get placed before us, and we are potentially being asked to draw a line, if you would, of where that scope of practice is defined and where the scope of practice between the two professions of physical therapy and veterinary medicine can complement each other or perhaps not complement each other. And so this is pretty much what this task force has been charged with, to help bring some clarity to that. As it is right now, if we don't define it, then it probably would all fall under the practice of veterinary medicine. If there's no definition, then it's all considered to be veterinary medicine. And as you can imagine, that might not be an outcome that we would want to see happen. Come on, guys.
Mr. Chairman, members, I think the fundamental question from a legal perspective is, just sort of thinking this out loud, is does this task force, I think there's a couple different ways to approach this. Number one is, if you want to say, this one thing is the practice of veterinary medicine. But if we change the statute, some licensee other than a veterinarian or RVT can do it. So you essentially toggle into the act and then you toggle back out. You follow what I'm saying? It's like, here's a subset of the practice of veterinary medicine. Whatever this subset is, let's call it X. Here's the people that can do X, X, Y, and Z can do that little thing. Maybe it's not licensees of the veterinary medical board. The other thing you could do is you could simply define veterinary medicine that whatever that one thing is, it's not the practice of veterinary medicine. Okay? So I think that's kind of, and then with that, I know that sounds sort of easy, but then with that comes the consumer protection obligation, the licensing obligation, the enforcement obligation, who's going to issue the license, all that sort of things. Who's going to do it? Who's going to enforce it?
I think you're jumping ahead for that. I don't obtain.
I stand corrected.
Well, so if I may try to bring up a point of discussion, one thing that I'd like to make clear, we're using the term physical therapy and animal rehabilitation. So we can't use the term physical therapy because that is a protected term. Could you clarify that?
Yeah, the initials PT or the use of the term physiotherapy or physical therapy is protected in the state of California, and executive directors in the audience can clarify that to more specific than that statement there. And so, it's funny that probably 4 years ago maybe, this discussion was always animal physical therapy until it was identified as, well, wait a minute, that's a protected term. It's funny how a lot of other states practice acts where they don't have that protected term, they call it animal physical therapy. And so this application of services to animals where we assist them in their course of health with rehabilitative techniques in many other jurisdictions is tantamount to what was called physical therapy.
Okay.
And so I think that's...
Can we have a consensus? Is there any member of this task force that is uncomfortable with the term that we're talking about is animal rehabilitation? The green button should be on.
Oh, there we go. When you say that PT, physiotherapy, physical therapy is protected, is that in reference to the license or to the act of performing physiotherapy or physical therapy, or both?
Well, as defined in, for us, it's under 2620, our BMP code. It defines what physical therapy is. And so the act that's titled physical therapy, as is identified in the BMP code 2620.
Is protected?
Yes.
But not the term physical therapy?
Yes, it is.
That as well, so
Yes.
both? Okay, thank you.
Would the task force consider, or can we change the term from animal rehabilitation to veterinary physical rehabilitation?
If we feel that would be helpful. So is there an issue with the term animal rehabilitation? Is that?
Yes, naming it veterinary anything, you imply that therapists and veterinarians together for the benefit of our patients. If we name it veterinary, we essentially say the PTs are not involved at all.
And I definitely can agree
Does
with
that mean they're not involved at all, or there's a level of supervision involved with it? Because we as veterinarians can decide who carries out what therapy or what treatment in our patients.
I think she's saying there's an implication.
So you're just talking about the overall
Yeah.
assumption, the public assumption that the term veterinary then precludes anyone other than licensees by the board. Is that?
The assumption is AVMA's definition.
Okay.
Okay.
Veterinary is a protected term. Only those who are licensed veterinary professionals may use that term in describing anything they're doing. So if we create this to be the veterinary physical rehabilitation task force, we are saying only licensed veterinary professionals can take part in this.
And I would ask members of the task force to only speak when recognized, avoid just bursting out questions or comments, just to keep the meeting in order.
What about animal rehabilitative therapy?
Okay, we have that term that's been thrown out. So we have animal rehabilitation and
Animal rehabilitative therapy.
I would like to propose potentially animal physical rehabilitation. I remember at a previous meeting that there was somebody from a veterinarian who does wildlife rehabilitation, and there was some confusion on omitting any type of physical act.
Kind of getting back to the discussion about veterinary rehabilitation, it's kind of like the veterinary in this word or in this phrase is the adjective. So when we go to a children's hospital, we don't expect that children are the doctors at the hospital, okay? But when we talk about a veterinary hospital, actually the modifier suggests that it's a hospital for veterinarians. So animal rehabilitation or rehabilitative therapy, to me it makes no never mind. I think rehabilitation is a horrible word to spell. I misspell it constantly. So I wish we could move away from that, but to me they're synonymous.
Yes.
Hi. From a consumer's point of view, and someone who has done a cursory reading of the legislation that you provided, I did notice that physical therapy is used in some of the other state laws. When all of this controversy sort of bubbled up in the summer of last year, I think there was some discussion out there in the internet world of that this was kind of a subterfuge for not dealing directly with physical therapy. I think that animal physical therapy is the correct term. I would know what that was if I was a consumer and I've got an 8-year-old dog. Animal rehab to me could mean anything from massage to massage therapy to taping to any of these physical manipulations, exercise, especially when you're talking about preventive and treatment and diagnosis. When you look at either end, the beginning and the end, if you're trying to prevent, I just feel that animal physical therapist is very plain and very indicative of what's going on. Thank you.
An observation that I had that might help us reach a consensus on what the proper term is was when I was reading the scope of practice of physical therapy, it seemed like there was 2 areas that possibly were addressed. One was actual corrective rehabilitation of an ailment, and then there were some definitions of how that was to be accomplished. But then it further went on and had some discussions about health and wellness issues. then there may be a distinction between what the goal of physical therapy is in veterinary medicine, is mostly for rehabilitation of a condition. And so I personally like the term rehabilitation as we're defining it within our scope of practice. Because, again, this is my opinion, I think that most of what we're doing in the veterinary profession is trying to rehabilitate a condition, not necessarily wellness issues, which might incorporate other modalities like massage and things like that. I will have opportunities for members of the public to make a point, but probably not until a little bit later. So hold that thought. I'll start over with you.
Thank
And
you.
my eyesight's really bad, so I'm sorry if I'm not calling you up.
Carrie
I just point to you.
Carrie Schlochter. Thank you. I just listening to this. Have not been to one of these meetings before, but we seem to be circling around two terms: veterinary and physical therapy. And if you go outside the U.S. to other countries, the term that I've seen used most commonly to describe, I think what we're trying to define here is veterinary physical therapy. It sort of combines both, and it deals with both trigger words, but it doesn't exclude anyone either from that perspective. So that would be my suggestion.
If, as Dr. Van Dyke and Dr. Sims pointed out, that each term is isolating of the other. So if veterinary means that no one other than veterinary professionals and physical therapy means no one other than physical therapy professionals, then my understanding is it would have to, we could not combine those terms. We would have to say something like animal physical rehabilitation. I have to echo what Kristen said, because at one of the meetings there was an animal rehabilitationist here who was very nervous about how this was going to impact her. They didn't do any physical therapy type modalities. They rehabilitated injured animals in a more broad term with housing and hygiene and things like that. And she was very worried that this would impact them. And unless we can write an exclusion to allow them to continue the work they do, I think we have to be just a tad bit more specific and have the word physical before rehabilitation.
If we use the word physical, would you anticipate any treatment modalities that might not be considered physical that would not be included?
Chemical, prescriptive drugs, as part of my rehabilitative patient care, chemical drugs, pharmaceuticals are part of that.
We're just moving along this way.
I think you hit a really good point where there's a difference between restoring function or enhancing function, and those are two different things. And my understanding of physical therapy is that it's restoring function from wherever that animal was. If you're taking it beyond where they were, or you're taking an animal for quote-unquote wellness care, that's kind of a different pony.
Chair Nunez, thank you. I think we have a couple different things we're sort of trying to figure out here. One is this whole notion of protected terms, so that the term physical therapist is currently legally protected in California, but on the other hand, as Carrie is pointing out, it's the term that the consumer recognizes, right? So if I go to a physical therapist for my shoulder, I know what that means. If I want similar treatment for my animal, I'll know what that term means. So as we're looking at consumer interests, how do we find language that's going to communicate what's going to then be provided? And then the other issue is, what are we actually talking about when we talk about what we're regulating, which is, I think, what you're trying to get at as well. What is outside the scope of this thing we don't quite have a name for, and what is it that we are here to regulate? Does that clarify usefully?
We're getting closer to getting a name, though, I think.
May I add, I wonder if there's an opportunity, and it might again involve legislative remedy, to open up the term physical therapist to a specific practice if we end up going in that direction. That is, just because right now it's kind of owned by the physical therapist doesn't mean that there might not be an opportunity to share its use with proper legislative approval.
Well, oh, yes, I will allow our executive officer to chime in.
May I make a suggestion? Jason Kaiser is the executive director of the Physical Therapy Board and is here on his own time to kind of help us through this very difficult challenge that we're facing. And if we could allow him a few moments to address some of these questions, I think that would help set the tone for how we move forward with the term. Thank you.
Okay. So, again, I will allow our executive officer and legal counsel to chime in at any time, not because they want to make us establish a position, but they tend to keep us in line of if we're going off track. So would you like to make a brief presentation then of who you are and what you can offer to this discussion?
Sure.
And you'll have to borrow one of their microphones, and you'll have to do it on your timer, because I'll allow no more than 5 minutes.
I won't take nearly that long. My name is Jason Kaiser. I'm the Executive Officer of the Physical Therapy Board. I am here at the invitation of the Veterinary Medical Board and Ms. Del Magnaio as a technical advisor, and we'll see how technical I can get. I raised my hand only to make a comment in that I think that there are some efficiencies that might be realized here in communication if we have Mr. Hepler chime in on the idea of protected term and title protection as part of your practice act. I think for clarity's sake, your committee member touched on something very significant, that it's what's the clearest thing for the consumer to hear. But at the same time, the reason title protection is so necessary for a profession is that it cannot be used inappropriately by anyone else, a layperson or another licensed profession for that matter. So in some instances in other jurisdictions where you've seen physical therapy being used by veterinary medical boards, their statutes or their authoritative statutes allow for it. There might be a difference in the language that was handed down by their legislature. Not to say that that's not an appropriate course of action here, because I think veterinary physical therapy is a very clear choice of words. Physical therapy, the words physical therapy are used in other practice acts within the state of California. The Chiropractic Act has the words physical therapy in it. And while that has created controversy in the past, I think we've found an even keel approach to how it's used. And I think Mr. Hepler may be touching on why title protection is important from the perspective of the consumer, would be a benefit to the group.
Thank you very much, Mr. Kaiser. I was talking to board member, task force member Heller. I think the legislature has given this august body sort of an oyster approach, and I think if I can be so bold, I wouldn't want to limit it to what's protected and what's not protected. The reason that we have title acts and practice acts is to protect the consumer. That's why we're kind of all here. So in fact, there's a term that this body believes, almost said it, that this body believes that would best suit your mission, then I would say go ahead and adopt it. Use that and just tell the legislature, hey, by the way, we came up with some really good ideas and we're going to have to change a few terms and conditions as we go along. So I really would that be a limitation, because like I said, I think the world is your oyster here. You think about the solutions, you're going to make a recommendation. If somebody says that's inconsistent with existing law, then the remedy is you change the law. Just like we have this problem or that problem or whatever problem we're trying to solve. So I would want to make sure that you're wearing a consumer protection hat, but I also don't want this body to be limited by what's gone before you, because I think your charge is to figure out where we go from here, looking forward, not retrospectively.
So I'll resume our comment section.
That's great. I think that if we could bring physical therapy in, it would improve clarity. I don't have a problem with that. Also, animal physical rehabilitation. I mean, this I think would be acceptable terms. But we wrestle with this, and it's not insignificant. I cannot call myself a veterinary dentist, but I can say that I'm a veterinarian who does dentistry. I cannot refer to my assistants or my RVTs as nurses, because they're protected terms. And so this is great discussion. I don't know that it's really the meat and the potatoes we need to be discussing today, but just the term is fine. I don't know that what really is important is the definition of what this animal rehabilitation modality is, and that's really, and who can do it.
And I anticipate that after we define the term, we're going to get to that point of listing out what that includes.
And I would agree with Dr. Klingberg. I think the important word in there is animal, because only veterinarians can do that whole list of things that Mr. Hepler addressed as far as animals go. I know Dr. Waldman's practice has rehabilitation in it. I don't think that's kept it from being an effective practice, or that she can comment on whether nobody understands what she's doing there. And also, I think the word rehabilitation is in the sports medicine rehabilitation board certification, so that's somewhat been established already, the word rehabilitation. And as you said before, this has been developing over a number of years. So I really think the key word is animal. I like the word physical in there, and I like the term animal physical rehabilitation.
Any further comments on this? Please do.
I move that we, what we're discussing today is animal physical rehabilitation. That we rebrand it from animal rehabilitation to animal physical rehabilitation.
It's been moved and seconded to redefine the term of what we've been tasked
Chair Ninian,
to address as animal physical rehabilitation.
are we going to be open to some discussion of the motion?
Yeah.
I'm not ready to vote on a term when I don't know yet what it's covering. So I'd like us to cover the definition first and then come back to Dr. Klingborg's motion.
Can we cover that in the discussion of the motion?
It seems like it's a pretty substantial point of discussion in its own right.
Oh.
So I'm sort of
no.
asking to table the motion.
I hear what you're saying.
Until we cover what it's going to describe. So naming something before you've figured out what it is you're naming just seems a little bit premature to me.
I get it. So the point that
That's fine. I can withdraw the motion at this point.
I would suggest that you table it.
Yeah, table it.
So we do have a term which I think ultimately we're going to agree upon, but Ms. Heather suggested that we table it until we actually start to define what's going to be incorporated in that term before we make a final vote on accepting this as the term. Does anyone have, well, how do we do that now? It's been motioned and seconded. And now,
Mr. President, members, if both the mover and the motion and the second would just sort of not gladly, but just sort of entertain the concept that we'll just sort of push this to the side and defer it, then I think we can do that, and I think perhaps we can tackle Ms. Heller's issue, which is to get the definition and then come up with a name. I think is.
So we'll leave it as an open motion.
We'll leave
and not
it
vote at this time.
Yeah, does the second agree just to defer it temporarily?
Yeah,
Okay.
I agree.
All right, thank you.
Welcome to my world, task force members. Okay, so in regards to this term that we have yet to officially adopt, there has been some efforts to find that in our history, which I'm sure many of you have copies of. And so maybe perhaps as a starting board, maybe we can agree to the thought that the treatment modalities that we're going to discuss are used in an effort to restore a condition as opposed to wellness or other treatments like that. If we can kind of keep in mind that as we define these modalities, it's for the purpose of restoring an ailment. And would you like to go ahead and start with a definition?
So if I may submit that we do have language that's been in front of the Multidisciplinary Advisory Committee in January of 2016 on animal rehabilitation. It did define this, it also defined what it was not. Quite frankly, I'm wondering if we don't want to get copies of this in front of everybody before we discuss it, because I think it would be easier than me reading this whole thing.
Okay, we can do that. So,
Excuse me, point of information, sir. We have copies of different state statutes, and I'm wondering what part these are to play in formulating this regulation. Are we to examine the differences between those statutes in defining what is animal physical therapy, animal whatever it is? Because there are lists on this Nevada. It's a very clear definition. It's .1234556. I'm just wondering what you see as the place of of us having these different statutes if we're not to compare them to what might be the outcome in terms of what's reported to the board.
we do have, as a resource, some definitions that have been made by other states. There's a lot of definition as far as levels of supervision and educational requirements, which we will have an opportunity to discuss later this afternoon. But this might be a good time to maybe take a 30-minute lunch break. And this is where staff has to help out a lot, is to get copies of different definitions of animal physical rehabilitation for us to use as a springboard to start the discussion. How's that?
I just want to play devil's advocate for a moment, which is not my most favorite position. But when you look at every other part of veterinary medicine, dentistry, surgery, internal medicine, cardiology, we do not delineate specific things in how we diagnose or treat those. We don't talk about dentistry and doing single-rooted extractions versus multi-rooted extractions versus doing root canals, all of those types of things. And while this area is a passion of mine or I wouldn't be here today, I just want to make sure that we treat whatever we call this as an encompassing part of veterinary medicine. So if we did this with dentistry, our list of what we do in the dental world would be enormous. And the same thing with the surgical world. We don't define soft tissue neurosurgery, orthopedic surgery, and then become more specific about those things. So I just want to make sure we look at this in a bigger picture while we're still protecting our patients.
Yeah, there definitely is a downside to over-regulating kids, for sure. So I think that while the rest of us enjoy a 30-minute lunch break, staff is going to, and myself is probably going to have to, what we're going to try to do is get together a list of what has already been attempted to define animal physical rehabilitation is, and use that as a springboard for discussion. So,
Now, with my, not I'm fully apprised about Open Meeting Act, 3 of us shouldn't sit around at lunch table and talk about stuff?
Oh, is that Bobby's question? What can they talk about during lunch?
You talk about the quality of your lunch and what your entree is, and that's about it.
More than that, as long as it's not about what we're doing here today.
Talk about Cavaliers maybe. Okay, sorry.
Question, do you want all of the previous iterations of the animal rehabilitation definition or just the most recent iteration at the last MDC meeting where we removed the wellness modalities from the definition?
I would like them all.
I think
there's only 3 versions, wasn't
well, I can't speak to anything before 14, so I don't know how many versions there are. I can get you everything before 14. And my fear is here, and maybe we can ask the task force members as a group, with all due respect, Chair, if we start bringing out the older definitions, I think we're going to get into the discussion that we've been in for a few years about recreational massage and exercise and that kind of thing, which I think may prolong where we're trying to get to.
Understood. Okay. Then we can have most recent. And then also what's with the other states protect.
That's a here at the table. And if there's any states that I can pull up at the break that aren't here that is recommended by the task force, I can grab those statutes or regulations.
Maine has recently passed some regulations that I completed last year, and they were sued and lost
Okay.
for it, and I think a lot is being sued right now, and they're,
Nevada is being sued.
Yeah.
Okay. And Maine,
Colorado, I believe.
Maine, you said are regulations and not statute.
I believe it was a statute, I could be wrong, but I'm pretty sure they got sued and lost.
Okay. So would you are you requesting that we pull Maine statute just so we can look at the difficulties they've addressed? Okay.
I'm sure that Maine,
Missouri as well?
Missouri.
yeah.
Missouri's
I'm sure that
there.
Maine didn't have as excellent legal counsel as we do.
Obviously
Yep.
not, since they got sued.
I was just gonna recommend that we do pull the language, at least the one prior to the one that Dr. Klingborn wrote. I can think of several discrepancies and things that will be coming up as we talk about things on our agenda, including level of supervision. And there are big differences. True, there are wellness, there's wellness wording that might be ambiguous, but it seems like we all are likely in agreement that ship has sailed and those wellness terms are not going to be included anymore in our definitions.
I can get it, Mark.
No.
Alright.
I can get it.
Okay. We'll see you all in the minutes.
Yeah.